Good morning, good afternoon, or good evening, dear audience, depending on wherever in the world you are. I welcome you to this evening's talk by Professor Melissa J. Durkee. Before I talk about today's topic, let me introduce Professor Durkee to you. Professor Durkee has a very impressive CV. I would not take too much of your time in introducing her works and her accomplishments. Let me just present a snapshot of her illustrious career. Professor Durkee is currently serving as the University of Georgia Law School's Associate Dean for International Programs, and she is also the director of Dean Rusk International Law Center. Professor Durkee holds the Allen Post Professorship. She teaches and researches in areas such as international and business law, corporate law, and international environmental law. Professor Durkee holds also a courtesy appointment in University of Georgia's Terry College of Business. Professor Durkee's scholarship has been published in some of world's best journals, such as Yale Law Journal, Stanford Law Review, UCLA Law Review, the Washington University Law Review, and the Virginia Law Review. Professor Durkee serves on the board of editors of the American Journal of International Law, and she also serves as the supervising editor of Agile Unbound. Professor Durkee is a member of the American Society of International Law's Executive Council, and she also has held several positions in other ASIL committees. She has given invited lectures and spoken to many academic and professional conferences, seminars throughout the United States of America and also across the globe. Now, regarding today's topic, when we think about international lobbying, we often think about the NGOs. Any one of us who has any familiarity with public international law, we know that theoretically, international legal system is based on sovereign states. But we also know that directly or indirectly, international businesses and NGOs, they play their role in international lawmaking in various ways. But I think what Professor Durkee has done very eloquently in her recent works is that she has illustrated that much of the academic attention has been devoted to the study of NGOs' role in international lawmaking, not so much the role of businesses, and even more on the various kind of access that various trade and lobby groups have, such as, for example, the International Coal Association, that how do they represent themselves in international institutions. Her work is very thorough, rigorous, and I think she has very poignantly and very rigorously pointed out that the existing theories of access by trade and lobby groups in various lawmaking bodies is not really adequately addressing the current realities. Professor Durkee is very careful in her scholarship. She is not claiming that these bodies could have no role or should have no role in international institutions. Rather, she is saying that the ECOSOC model or the other models that are there are often not adequately addressing the current realities. And through her scholarship, she has presented some alternative theories of international lobbying. At least when I have read her works, to me, they were very illuminating. And I'm sure her today's talk will be very engaging and thought-provoking. I look forward to Professor Durkee's talk and also to your questions, dear audience. I'm sure we would get some food for thought. And before I finish, I would once again like to thank Professor Durkee for her time. Thank you all. Professor Durkee, the floor is yours. Thank you.
Thank you very much. Thank you very much, Professor Islam, for that generous and thoughtful introduction. So I'm very happy to be here today. One of the unexpected pleasures of the pandemic has been about how it's continued the process of globalization and shrunk the world even more, so that I here in the bright sunny morning of Georgia and visit with you all in Bangladesh. So I'm delighted in the evening. So I'm delighted that you are willing to stay up long enough to join this conversation. And I'm very happy to be here to speak with you. So if you've been following world news, you might have recently been watching the reports of COP26, the Conference of the Parties to the United Nations Climate Change, or Framework Convention on Climate Change, the 26th Conference of the Parties taking place in Glasgow. And as you know, just this past Saturday, this Conference of the Parties ended, and there's all of this discussion about ways that the world can better address climate change, right? What can we do to further reduce emissions? Are we going to phase out coal? What are we going to do for the loss and damage of nations like your own that will disproportionately face the effects of climate change that you mostly did not create? So if you're following along, you might have seen that one of the stories was about participation of non-state entities in the proceedings. One of the stories was about how hard it was for NGOs to get access to the proceedings, to intervene, to witness the proceedings, and at the same time, how seemingly easy it was for big fossil fuel interests to gain the ear of the negotiators. So here are some of the things that were reported on Twitter and in the mainstream press. Of course, some of this needs fact checking, but these are the kinds of reports that we were hearing. NGOs spending 4 hours in line to get into the climate summit. One door for 20,000 participants in the summit that they all had to filter through. Reports that these participants were actually locked out of the negotiating spaces where the delegates were doing their work to negotiate. With no video link or way to observe the proceedings or interact with delegates. There were reports that eventually the organizers just stopped letting people in, blaming the pandemic, and suggested that they go and watch from laptops in their hotels. Sort of problematic for people who had saved up, earned or found the money to come to Glasgow and participate in these proceedings. At the same time, there were reports that fossil fuel companies were given more access, that they were pulled out of the line and brought to the front of the line. Australia's official pavilion was sponsored by gas company Santos, and the logo for their climate pavilion looked startlingly similar to the Santos logo. There's reports that the IETA, the International Emissions Trading Organization, which is a lobbying group for fuel companies like Chevron, Shell, and BP, had a delegation there that was over 100 strong. And we heard about ExxonMobil at the table. So what's clear here is that there is a strong perception in this reporting that things should be otherwise. And you and I might share this intuition, that perhaps access by fossil fuels might somehow taint the proceedings. Maybe the delegates are in the pocket of the industry interests that are pitted against the very climate change goals of the conference. That perhaps NGOs should have more access to report on the proceedings, to ask hard questions, to hold the delegates' feet to the fire. That's a strong perception coming out of this reporting. What I want to talk about today is how international institutions engage with non-state actors, particularly these business actors and industry and trade groups who want to participate in law and policymaking processes. How should international organizations respond to them? Should they exclude them entirely? Should they treat them just like other NGOs? Should there be separate regimes for the two of them? And how are we really thinking about the goals of participation in the international global governance sphere? So in talking about this theme, I want to cover three different areas. First, I want to really highlight and point out the ambivalence of our current approach and some of the reasons for that ambivalence. I also want to talk about some of the models that we use. What are some of these legal frameworks that we use to admit different interests into these law and policymaking spaces, or to keep some of them out? And third, I want to talk about how challenging it is to design a good system, but also to offer 5 factors to think about and trade-offs that might come when you're considering these 5 factors, and how we might put them together to design reforms. So first, let's talk about how the international system's current approach expresses a good degree of ambivalence. So the drama at this COP26 climate conference is part of an increased tension that's been developing. On the one hand, there's this perception that the participation of fossil fuel interests at the climate conference and others is nefarious, right? This seems almost self-evident. After all, these trade and industry groups bear reputations as really powerful lobbyists, and justifiably so. Sometimes this is directly against global public goods, right? So these groups lobby on behalf of multinational corporations, which have a really checkered history when it comes to environmental and human rights movements. If this is your intuition, you're not alone. Shareholders at the multinational gas company Chevron decided in the spring of 2020, in this sort of landmark movement, to target climate lobbying by trade associations. They voted to approve a shareholder proposal asking the board of directors to report on any money spent on climate lobbying. And the proposal actually passed, which is very rare in the context of shareholder proposals in the United States. So there's even a movement among shareholders to major multinational oil and gas companies to try to hold those companies to account for international lobbying that might be at odds with global public goods, like response to climate change. And Chevron shareholders are not the only ones concerned. A group of 75 civil service organizations published an open letter to the United Nations Secretary General of the UNFCCC, the United Nations Framework Convention on Climate Change, 5 or so years ago, that was really calling out the exclusive access to negotiators that was being provided to corporate lobby groups, including the coal industry, and then the risks of these interests. They called for a better set of rules to regulate the relationship between the UNFCCC and the fossil fuel industry. So this is all happening on one side. There's this intuition that industry groups in global governance are problematic. On the other side, as I said, we have ambivalence. On the other side, the United Nations is really seeking aggressively and actively to engage with private sector actors across a variety of agendas and international bodies. So we see this in the Sustainable Development Goals and Agenda 2030, which encourage engaging with business groups to accomplish goals like ending poverty and combating climate change. There's now, in fact, a UN Office for Partnerships that exists to, and here I'll quote, mobilize and share knowledge, expertise, technology, and financial resources towards the achievement of the Sustainable Development Goals. There's also a Sustainable Development Goal Fund that explicitly engages the private sector, a highly developed training program to establish public-private networks and partnerships. And that's just in the Sustainable Goals Development Goals area. Also, the UN Guiding Principles on Business and Human Rights, which I'm sure you're familiar with, seeks to engage businesses directly, enlist their support in looking out for human rights around the globe. There's new multi-stakeholder organizations like the Global Fund to Fight AIDS, Tuberculosis, Malaria, and UN Women that offer decisional rights to private sector groups and as an explicit vote, a seat at the table, and let them help set the agenda, in part because they're getting valuable things from these private sector partners, like funding and like their support in carrying out the mission of these organizations throughout their value chains. The UN General Assembly recently went as far as to grant observer status to the International Chamber of Commerce. So there's an increasing push at the United Nations and other institutions of global governance to engage with the private sector to carry out sustainable development goals, to engage with the private sector in the protection of business and human rights, other environmental sustainability, corporate social responsibility goals, and to enlist private philanthropists and funders in a whole rash of important international agendas. And a scholar that I have a kinship with, Eilert Berman, describes this trend as a transformative move toward opening up by international organizations that spans all issue areas, policy functions, and world regions, and it is gaining momentum. So I recently spoke on a panel that was called Between Participation and Capture. And I think that phrase really captures this ambivalence and this tension between conflicting values that we're seeing now in the international approach to private sector lobbyists and partners. If we think of international organizations or non-state actors, participating in the work of international organizations, then we think about open, transparent organizations that are receiving the benefit of diverse perspectives and perhaps expertise. We think about process, access, legitimacy. That's what we think about when we think about these values of participation. On the other hand, if we think about capture, we think about non-state actors capturing the agenda of international organizations. We have an opposite set of mental images. We think about corruption, mission drift, the erosion of legitimacy. And of course, we have great historical examples of both of these things. On the capture end, the World Trade Organization has been the site of a number of battles. These include highly organized efforts by the tobacco industry that were often covert, as the tobacco industry hid behind NGOs, academics, developing world farming associations to push their agenda, often in a covert way that wasn't transparent. And then the WHO has also been the site of more recent struggles over pharmaceuticals and sugar. At the same time, industry representatives have been really important contributors. As I said, they've been partners to organizations like UN Women. They've been contributors to a balanced process as long ago as the International Labor Organization, founded in the early 20th century. They've provided really useful expertise at a number of different law and policy making forums at, for instance, the United Nations Commission on International Trade Law, UNCITRAL, and the International Institute for the Unification of Private Law, UNIDROIT, where their input was indispensable to creating rules that will really be feasible for compliance by companies that are trying to create a good environment for their business entities. And you can see why this kind of expertise might be useful. Recently, the Microsoft, Brad Smith, Microsoft CEO, was calling for a treaty on cyber attacks by foreign nations. He was calling this a digital Geneva Convention. I think probably digital Geneva Convention is the wrong way to talk about a treaty on cyber attacks from foreign nations. But the point remains that Microsoft and other tech companies that are heavily involved in researching consumer security, and Apple and so forth, they might be helpful partners if the international community wants to design a treaty or other policy responses to cyber warfare. This expertise can really help drive a project like this forward. So the point, as you've seen in that, and I don't mean to beat it to the ground, but industry representatives can have both positive and negative effects on international law and policy making. And so it's because they can have both effects that we're really ambivalent. We're ambivalent in the legal structures that are currently exist, and we're ambivalent in the way we talk about these partnerships. And we really haven't done enough work talking about this, thinking about this, theorizing this in the literature as well. And so it's really challenging to design access rules that capture the benefits and avoid the harms of this participation. Because of that challenge and because of this ambivalence, we really haven't addressed this topic nearly sufficiently yet. We're just living with the ambivalence. So Where to go from here? The challenge is, of course, a way to facilitate benefits and restrain harms. And I'm going to argue that there's no silver bullet way to do this. I apologize that I can't give you the silver bullet, but this is a great area for more minds to come on board and think about it. And maybe some of you will take this up as a project in the writing that you're doing for school or your careers afterwards. So what are the benefits? We've seen that business representatives can offer expertise, develop technical standards, serve as essential stakeholders whose acceptance will be necessary for the rule to succeed. They can offer funding for important global projects, serve sometimes as neutral parties to facilitate compromises between states that otherwise might not be inclined to compromise. And I wrote a previous paper exploring this in the context of the Cape Town Convention on Interests in Mobile Equipment, which is about financing of aircraft and aircraft engines, where it's really interesting. The private sector consultants or industry groups that were at the table, the aviation working group, really helped develop language that was acceptable to civil and common law countries, which otherwise weren't coming together because nobody wanted to sacrifice their distinct approach to the law. So it was really the industry group that served as a neutral third party. So there's benefits. What are the downsides? Capture, subversion of the regulatory process. Lobbyists can have a second bite at the apple. They can go lobby their domestic legislatures and then go lobby at the international level. Do we want this? And then also it can exacerbate imbalances between the global north and south, right? Often these lobbyists are representing massive global north companies with a lot of resources. And so the perspectives you hear at these law and policy making forums is by negotiators in the global north and lobbyists from the global north, which can imbalance the perspectives that you hear when discussing important treaties like the climate change efforts. So what are the regulatory models that we have now to try to balance this? Well, interestingly enough, we are largely using a model that's really, really old, a model that existed in the League of Nations era before the UN came to being in the middle of the 20th century after World War II. So in the League of Nations era, there was a close and cozy relationship between international organizations and other associations, and no real distinction between business associations or lobby groups and other kinds of NGOs. So you had the International Chamber of Commerce operating right alongside international groups that were trying to advance the rights of women, labor groups, all operating together with these really young international organizations like the International Telecommunications Union that were trying to organize international affairs. So after World War II, the UN Charter imported this working method into the new system, but also gave NGOs and non-international organizations a lesser status. So they were conceived of as consultants to the Economic and Social Council, which of course is a organ of the United Nations. And so the UN Charter authorized the ECOSOC to design an accreditation system to allow these organizations to have a partnership and relationship with the UN and to participate in the work of the UN. And so ECOSOC did design this accreditation system through a series of regulations. And now different organizations can apply to become consultants to ECOSOC and to the United Nations. And this is really popular. At this point, about 5,000 organizations have registered and become accredited with consultative status at ECOSOC. And of these, 10% are industry or trade groups. So you have organizations like the International Chamber of Commerce, the World Coal Association, the National Association of Home Builders of the US, the Association of Latin American Railways, among others, right alongside groups like the Sierra Club, Greenpeace, Heifer International, other Red Cross, other well-known NGOs. And once accredited, all of these groups have the same access rights. They can send representatives to sit as observers at meetings, present written or oral comments on agenda items. They can lobby informally by accessing UN facilities and places where lawmakers and officials gather. And so this isn't the only model of allowing NGOs and non-state actors to have access, but it's a really standard one. And many other organs or agencies of the UN either use a similar model or piggyback on the ECOSOC accreditation. They say, if you have to be accredited with ECOSOC to participate in our work. And so let's talk about this model for just a moment. It has two main problems when it comes to industry groups. First, it doesn't regulate industry actors very well. And that is because individual business entities are not permitted to access this accreditation scheme because it requires nonprofit status, but trade and industry associations are admitted on the same terms as other kinds of NGOs. And yet the screening methods aren't really designed to apply very well to industry groups. The rules seem to be concerned with a group's internal governance rules rather than with who funds it or what interests it represents. So they ask questions about, does this group have democratically chosen representatives? Does this group have a constitution? And it doesn't ask questions like, who are the major contributors, donors to this organization? What are its lobbying positions, et cetera. So even though business groups and other kinds of NGOs are admitted on equal terms, the rules really seem to be having in mind NGOs and whether they are representing groups of individuals in the international process. Okay, so that's one problem with the rules. The second problem I see with these rules is that they don't give a very meaningful amount of access to international law and policy proceedings. Non-state actors can make comments, but they can't vote. They can informally lobby in the hallways, circulate proposals, but they aren't really participants in the process. And this is some of the criticism that you're seeing coming out of COP26, that they're really marginalized and they want to have more access to make more of a difference in these climate negotiations. So if we're thinking about participation versus capture, my critique is that the ECOSOC rules are not really designed to help on either front. They don't really allow tremendously meaningful participation, and they don't do much to guard against capture. So what other models are possible? Well, there's a number of more recent reforms or access rules that have responded by tweaking the ECOSOC model to improve things, but they tend to push in one or the other direction. They're either improving access and participation, or they're responding to the capture concern, but not balancing those two very well. So on one that's focused on capture is the WHO's, World Health Organization's, framework of engagement with non-state actors, and this is one of the main innovators here. The WHO is using this new framework to try to weed out the tobacco and the arms industry that have caused them trouble in the past, and separate classic public benefit NGOs from private sector groups and give each separate access rights and separate protections. The Food and Agriculture Organization has also done reforms like this to separate these kinds of groups and give them different kinds of access. But another set of organizations have responded in the opposite direction. They responded to the other critique, and that is the participation critique. And this group is moving towards multi-stakeholder models that increases the participation of non-state actors, giving them full membership and voting rights in all or some part of the organization. Now, we've seen this from the International Labor Organization as far back as the early 20th century, but there's also newer organizations like UN Women, as we've discussed, the Gavi Alliance, the Global Fund to Fight AIDS, tuberculosis, and malaria. And I would argue that choosing among these kinds of reforms really depends on an organization's distinctive needs. Organizations that draw substantially on private sector assistance for expertise, voluntary compliance, financial support might be more likely to benefit from a multi-stakeholder structure that brings on industry partners, whereas organizations that require substantial support and buy-in from national governments should probably tend towards the classic eco-structure that preserves more national sovereignty over the issues, and think about reforms that cast sunlight on the process and bring to light what these influences are with better regulation and disclosure rules. And then the trickiest reforms will be for organizations like UNCITRAL that fall in the middle. On the one hand, they need support they need national support, state support, governmental support in order to obtain national implementation of the rules that they come up with. On the other hand, the main consumers of the rules are private entities, so they rely heavily on private sector expertise as well. So in just a moment, I'd like to give you what I think are 5 considerations that we should keep in mind when we're choosing between these 2 reforms or designing reforms of those 2 models, the multi-stakeholder model or the WHO separate channel model. I'm going to give you 5 considerations to think about and trade-offs, but before I get there, one last point I want to make is that one of the really interesting things to note about why it's so difficult to design a good rule scheme is because, as Professor Islam said at the beginning, we've had this obsession with non-governmental organizations and really haven't adequately acknowledged that industry and trade groups are among those organizations and among the groups that have been participating in the process all along. So our focus in thinking about these schemes has really been on these classic public interest or public benefit organizations like Amnesty International, Greenpeace, Doctors Without Borders, et cetera. And in fact, in the 1990s, there was this great burst of enthusiasm about NGOs participating in global governance. And I call this legitimacy optimism. There's this idea that NGOs participating in global governance would be a democratization of international governance by bringing all of these voices to the table that weren't adequately represented by their governmental delegates. And so listen to some of these expressions of what I call legitimacy optimism. UN Secretary General Boutros Ghali called NGO activity a basic form of popular representation in the present day world, a guarantee of political legitimacy. Later, Secretary General of the UN, Kofi Annan, said the rise of NGO consultants is a revolution and a global people power. And then in a 2004 report on the consultancy program, UN officials said, the growing participation and influence of non-state actors is enhancing democracy and reshaping multilateralism. You can see how that tone of optimism has changed a bit in the present world we've inherited today. But at the time, there was discussion about whether there was even a global norm emerging, that NGOs have a right to consult, or that international organizations have a duty to receive consultation by these NGOs. But even while all this discussion was happening, all this celebration of NGOs, business interests were right there at the table too. And sometimes obviously, and we just weren't noticing that in our conversations about people power, and sometimes less obviously. And I, in a prior work, talked about Astroturf Activism in international law. Like, for instance, the National Wetlands Coalition, a nonprofit formed by US oil companies and real estate developers, but it's called the National Wetlands Coalition. This was an organization that was accredited as a consultant at the ECOSOC, or the Citizens for Sensible Control of Acid Rain, which was formed by coal and electricity companies. So there were these business interests lurking behind these innocuous sounding NGOs that seemingly were advancing public interest agendas. And then, of course, there's all sorts of partnerships between NGOs and corporations that have complicated this as well. Cargill Corporation, the agricultural giant, has a partnership with CARE International. This CARE International has consultancy status at ECOSOC. So so we've had this rhetoric about the benefit of NGOs without necessarily recognizing the place that businesses should have in that rhetoric or in the rules that we develop. And in any case, the enthusiasm about participation by NGOs started to diminish a bit after in the early 21st century, when NGOs started to more aggressively critique some aspects of global governance. That kind of led to a backlash. So we've talked about the ambivalence of in the UN and in other global governance structures towards business groups. We've talked about some of the structures that exist currently and how they came to be that way. What about what we should do going forward? How should we resolve this ambivalence? How should we choose between structures? How should we reform those two alternative models that are themselves a reform of the ECOSOC models? So here are things I think we should be thinking about, and I'll give you 5 of them. And the first 3 of these factors are really closely tied to legitimacy. So what should we be thinking about in designing reforms? First, we should be thinking about accountability to mission. So can an international organization pursue its mission without getting derailed by special interests? And this is what we're talking about when we're talking about concerns with capture, concerns that an organization will have to pursue the mission of the special interests that are lobbying it at the expense of its own mission. So the reason why we need to think about this is that some organizations will have missions that demand more engagement with the private sector, others more protection from it. And so the first question we should always ask is what participatory structure will help an organization hew to its mission? And it's this factor that means that we'll have different structures that will be a good idea for different organizations. There's no one size fits all solution. The second thing we should be thinking about is balance of perspectives. And this is the value that scholars are invoking when they call for the democratization of law and policymaking processes. They want all sorts of people at the table. And one of the challenges, as I said before, with opening up an international organization to non-state actors is they tend to amplify some perspectives and drown out others. So we need to make sure that in any particular structure we're designing, those who are affected by the rules should have meaningful access to participate in the process. And the structure will need to make sure that those groups are in some kind of equilibrium rather than dominated by a particular interest. The third thing I would propose we think about is meaningful access. So it are the participant rights that this access rule is offering, giving the non-state groups a chance to provide real input. So to the extent we want non-state actor participation at all, one would presume we want some sort of meaningful access. And this is particularly a concern if we actually want the information expertise that the private sector may have to offer. Let's see, that was 3, right? Okay, the fourth thing was that, okay, no, that was 4. We have accountability to mission, balance of perspectives, meaningful access. Oh, the fourth thing is transparency, right? Transparency can help with legitimacy, right? So allowing private groups access to the rulemaking process can enhance transparency because those groups can disseminate information to their members. Of course, it's also a key rule of law value. It's important to know who is participating and shaping law and policy. Strangely, many international access structures have tended to focus on representation at the expense of transparency or over transparency. Okay, so accountability to mission, balance of perspectives, meaningful access, transparency, and the last I would say is administrability. So are the access rules designed in a way that they are feasible or administrable? Is it really feasible for IO officials, organizational officials, to ferret out who or what interests a group represents? To the extent we want to make separate paths, as the WHO and the FAO have done for private and public groups, we have to make sure we're able to determine who that group is speaking for. So the gatekeepers need enough information and bandwidth to evaluate groups effectively. So a better course might, in some cases, be for international organizations to use a less heavy-handed governance framework where they're sorting out what interests are behind each organization. We might design rules that accept input from all sources presuming that they will represent a diversity of interests. Okay, so I hope you can see, we can talk about this more in the Q&A. I'm going to wrap up to leave some time for discussion, but I hope you can see that these different factors can push in different directions, suggesting trade-offs from different values. So I guess that what I would leave you with, and I invite your reactions and your intuitions here, but a lot of our participation structures are understood as products of path dependence and of sort of ignoring the private interests at the table. We need to recognize and confront the ambivalence that we currently have towards business interests to be able to design better participatory structures. And we should pay close attention to the experience of the innovators like WHO and FAO and the multi-stakeholder organizations to try to figure out what's working and what's not. All right, so with that, I'll turn it over Professor Islam to accept any questions or any intuitions or reactions you might have.
Thank you. Thank you, Professor Durkee, for your excellent presentation. We have quite a few questions, so let me raise them to you. First one is requesting you to share your thoughts on what your critics may say about the inefficiency of involving too many actors. So as I understand it, the question is really asking that if you make too much regulations about lobbying by private groups, particularly trade groups, could the treaty negotiations become more cumbersome, more dragged on? Thank you.
Yeah, that's really, that's good. And I think that this questioner shares my perspective that one of the important things we should be focused on is administrability, right? A whole structure and system is no good if it can't be administered, if it is too cumbersome. And so I guess what I would really like to encourage us to think about as we're thinking about these access structures is the distinct needs of different organizations, right? So a private sector organization like Untitled or UNODWA that's helping nations produce rules that governs private sector affairs, contracting, bankruptcy, the financial world, security interests and things. In those circumstances, governments might really need the expertise of professional organizations and industry groups that have a lot of expertise with that particular kind of the laws that currently exist in different jurisdictions and the kind of laws they need to do business efficiently, right? And so in this circumstance, you certainly don't want to have a rule that that is too cumbersome to allow these interests to participate. You need to be focusing on the particular groups that might bring something useful to the table. But in something else like the UNFCCC, the climate change context, even if it's really important to have fossil fuel interests at the table, even if they are bringing expertise, or even if their buy-in is necessary to create rules that will be useful, there's a huge legitimacy problem when fossil fuel interests are getting front seat tickets to this tickets is metaphorically here, but getting a front seat to these proceedings and really are perceived to have the ears of the negotiators, and everyone else is standing in 4-hour lines and being sent back to their hotel rooms and can't have any access at all to the negotiators. Even if you want expertise, that's a big legitimacy problem, and that's a problem for international governance and for the willingness of different international communities to buy into what's going on in Glasgow or in Paris or in any of these major climate conferences. So I guess I've gone a tiny bit afield from the original question, which was about the cumbersomeness of this. But in that circumstance, maybe you do want a more cumbersome means of registering access so that you have a better balance, right? And so you don't have this perceived disjunct between fossil fuel interests and everyone else. I hope that answered it, but I'd be happy to take a follow-up on that as well.
Thank you. So the second question asks, I'll read it out for you. Is there an inherent danger of businesses lobbying in international institutions in some sensitive areas of policymaking? Say, in the UN Security Council meetings, states do not allow private bodies to join. So could there be some areas where this private lobbying scope should be totally restricted? Any thoughts on that?
Yeah, so you're saying, is the question that so as we've discussed, in some areas there could be some benefits of including the private sector, but you're saying, are there other areas where they should be excluded completely because they have such a detrimental effect on the proceedings? Is that the question? Yeah. Okay. So yes, I think that is really what we've seen at the World Health Organization, right? So even then, I would modify it just a bit and say there's no proposal that they be excluded completely. However, the World Health Organization has designed this really innovative two-track system where there's the NGOs have access on one level and private sector interests have access on another level, so that all the decision makers at the WHO know at all times who they're dealing with, right? What influences they're hearing and being exposed to, and they can limit the access by business groups in some way. And there's very good reason for that, because I alluded to the tobacco and the sugar and the pharmaceuticals fights before, but the tobacco one, I think, is really extreme, where the tobacco industry, when the World Health Organization was designing a response to a treaty on tobacco, they just used all these different methods to try to infiltrate the WHO and influence them. For instance, they would fund academics who wrote papers on the fact that the harms of tobacco were no greater than other harms and overstated. And they also posed as, they assumed control of and controlled the agenda of a small tobacco growers, small developing world tobacco growers association. So the Tobacco Growers Association was advocating what the tobacco industry wanted, and no one at the WHO knew that it was really just a mouthpiece for the tobacco industry. And as I said earlier, there's all sorts of different NGOs that are in partnership with or funded substantially by or have board members of major industry or multinational corporations involved in their work. So the WHO said, okay, we are trying to advance global public health, and this pits us directly against entrenched and powerful interests of tobacco, of food and drug lobby, pharmaceuticals. And so we really need a better protection mechanism so that our policymakers and lawmakers know who is speaking at any given time. And so they have a rigorous screening mechanism to try to understand whether these NGOs are funded by those private sector interests and who is really speaking, so that when they're trying to aggregate feedback on a particular rule change, they have a better view of whether this is an industry lobbying position or whether this is a true position backed by responsible academic research or the perspectives of small enterprises and so forth, consumers and so forth. So yes, I guess the short answer to the question is I absolutely think that there are times when it's very dangerous to have lobbying interests at the table, and that's and one response might be to try to exclude them entirely, and we really have to watch the WHO's experience to see how that works out. Are they really able to marginalize those interests through this two-track access system, or do they creep in another way? Because it's really difficult to exclude them entirely. Although, and there's no organization I know of that has done that completely or even chosen to, because of the benefits of partnership in some instances. So there's two challenges, like, do we even want to, and is it even possible? We'll have to watch the WHO's experience to see.
Thank you. The next question asks, not too many countries have regulations on private lobbying. So maybe the model that is there is perhaps the US model and some other OECD countries model. So would US-like regime be amenable to many other states who may be inherently more cynical about private lobbying in international institutions?
Yeah, great question. So yeah, so lobbying is regulated differently in different places of the world. That's true. There are some efforts by the OECD and Transparency International, at OECD, the Organization of Economic Cooperation and Development, Transparency International, an NGO, a think tank, to set out models that governments could use in trying to respond to lobbying in the national context. And in a prior work, I have thought about this lobbying model as a framework and how that's different from the consultation model framework of ECOSOC. And ECOSOC, you even hear in the terminology of partnership that, or consultancy, that non-state actors, including business actors, have been perceived as consultants, helpers, participants in the work of organizations. And that's been the case ever since at least the turn of the 20th century in 1900. On the other hand, when you go to a lobbying framework, whether that be the rules that you see in a particular jurisdiction like the United States, or the rules advanced by the OECD or Transparency International, a lobbying framework focuses on different kinds of things. It focuses on sunlight, right? It focuses on a lot of disclosure about who it is that's speaking, what their lobbying positions are, and whether the people who are speaking are in a revolving door relationship with government officials. Like, have they just left government and now are lobbying? Are they going to leave their lobbying position and then come into the government to implement those ideas? So they focus on a different set of issues. Who is funding this? What interests are you representing? And I think that in the context of the private sector, focusing on those kinds of issues might get us to where we want to be, rather than focusing on the issues that the international system has traditionally focused on with respect to NGOs. And that is, are you advancing a position that has been democratically developed through your membership, right? Have your membership voted on a platform that you're now advancing at the international level? And you can see where that's going. It has this kind of democracy frame to it, where we're thinking about all of these different individuals speaking through their organization at the international level. But that doesn't get us very far when we're thinking of industry and trade groups, because yes, the individual companies might be voting on a policy position, but when those individual companies are Chevron and ExxonMobil and so forth, we're not really getting helpful information by asking whether your members voted on a policy position. That's not what we care about. What we care about is who is funding this? What are your lobbying positions? Are you in some sort of improper relationship with government officials through bribery or revolving door sorts of things? So I think if we change, and these might be subtle tweaks in the existing laws, but if we change the framework by which we're thinking about private sector interests versus public sector interests, we might get at the kind of concerns that ExxonMobil at the COP26 might raise.
Thank you. As I guess I recall, one of the US presidents say that sunlight is the best disinfectant. So
yes.
maybe the more disclosure is there, maybe the more safeguard is there. The next question is, do states in the global south have some valid reasons to be worried about more private lobbying access in international institutions?
Yeah, so do countries in the global south have reason to be more concerned about this perhaps than other people in other areas? I think absolutely, and this is one of the concerns that I raise throughout my writings on this. I think that one of the problems is that there are too many people at the table, and we see this in COP26, right, where there's this massive amount of people that are trying to get in to the forum. And we also see how it's hard to give meaningful access to any groups when there are so many groups vying for attention. And unfortunately, I think that this often works to the detriment of the global south. I think that I saw some reporting a few years back about the top 100 NGOs. And first of all, the top 100 NGOs had a startling number of links with private industry, right? Private industry, or the arms industry, the tobacco industry, the fossil fuels industry on their boards or providing significant funding. So first of all, that was startling. But the other thing was startling is how of the top 100 NGOs, a disproportionate number of them are a radically disproportionate number of them feature people educated in the global north, funders from the global north, projects of the global north. Even if those projects seem aimed at the global south, they're disproportionately representing the perspectives and organized by and led by the global north. And so I think that that trickles into the kinds of perspectives that negotiators are hearing and policymakers are hearing at international institutions. We have this concept of juridical equality, where all nations are supposed to have equal weight in international forums like UNFCCC or the General Assembly and so forth and so on. But in practical terms, when so many of the consultants, the NGOs, and the business groups are represented by the global north, they can drown out the perspectives of groups that are really from the global south. So I think that that's certainly consideration in trying to design better access rules, is how can, in the 1990s, there was so much enthusiasm about how these NGOs were representing the whole world, right? Bringing the concerns of everyday people to the table, and how that was going to democratize everything because more concerns could be reflected than filtered through the national delegations, right? But if what we're hearing is that 90% of those additional people at the table are from the global north, then really that's not a democratizing influence. It's a skewed influence that's really further entrenching global inequalities. So that's something I think is really legitimate to be concerned about.
Thank you. We are almost running out of time. Maybe I'll just ask you one more question with your permission, because we are actually approaching, I think, 11 a.m. Yes, Eastern time. So are you happy with one more question, Professor Jackson?
Sure, let's do it.
So this would be our last question. How good a job is the current set of rules doing in differentiating between public groups such as Greenpeace from private business interest groups such as the International Coals Association?
Okay, so the answer for ECOSOC is that ECOSOC doesn't even try to distinguish, right? All of them use the same accreditation system. You can actually go look it up on the ECOSOC website. There's currently around 5,000 accredited organizations. And in my research, I found that 10% of these explicitly state that they're business and industry groups. And then there's a vast amount more that certainly are feature industry groups on their boards or funding or partnerships and so forth. So ECOSOC doesn't try at all. WHO does try. It tries to separate financial interests, business interests from other kinds of public interests and regulate these separately. But we don't have enough experience of that framework of engagement to know yet how well they're doing at it. Others of these multi-stakeholder organizations will give particular businesses decisional rights, a seat at the table, full partnership in these groups. And so what they're doing is admitting a much smaller number of partners, but they're explicitly partnering with private sector groups. So you kind of see here a whole spectrum, right? From ECOSOC, which doesn't even try to separate them, all the way to these multi-stakeholder groups that have equal partnership rights for private sector groups because they feel that that's good for their mission. So I do think that we might get lost a bit somewhere in the middle. I think either of these end approaches, the ECOSOC approach or the multi-stakeholder approach, could be useful for different purposes, but I think we might get lost in the middle in this WHO approach. I don't know how possible it really will be for them to do what they're setting out to do in the FAO and different models like this. And the UNFCCC does this a bit too. It has different tracks for bingos, which are business NGOs and other groups. Although they have the same access rights, they're just organized for communication purposes and so forth. I don't know how well we're going to do in that middle ground where we're trying to separate business interest from public benefit. And maybe it's still worth trying to do this, even if we do it imperfectly. But because we've seen such infiltration of public benefit NGOs or explicit Astroturf activism, just a moment on that phrase, Astroturf activism. Have you heard the phrase grassroots activism? So grassroots activism is individuals coming from the ground up, presenting an approach. So astroturf is pretend grass, right? So it's the turf, plastic grass you put in sports playing fields. So the plastic grassroots activism is the grassroots activism that's pretending to be people power kind of activism and really funded by public or by private interests. So we've seen so much of this secret, covert astroturf activism that I think, it might be difficult to ferret that out and to really separate these two groups. So we might have to press towards one of these more extreme models, admit everyone like ECOSOC does, and then focus on sunlight, transparency, exposing what people's lobbying positions are, or go to the multi-stakeholder model where you really, in instances where you need private sector partners, but then make sure you know why you're doing that and who is represented at the table and try to be balanced about the way you do that. I think the middle zone might be the hardest.
Thank you, Professor Durkee, for your excellent answers, and also, of course, for the presentation, which I'm sure our audience have enjoyed. With that, we are already out of time. Once again, thanks to all the audience, and of course, Professor Durkee. We had a wonderful session. If any of you have missed any part of this session, we would soon upload it to our YouTube channel. So please do watch out for that. Professor Durkee, thank you for your time once again, and the esteemed audience. We hope that you would be with us for our next webinar session. Thank you all. Once again, goodbye from the Department of Law for this session.
Thank you very much. It was a pleasure being with you today. Have a good night.
You too.